turn off the Google Earth. Okay, we can do a little breakdown of Rosa's. I mean, she kind of explained it to us the other day without having to break down. Of course, she was completely haggard and hadn't slept in 2 weeks at that point. Um, but basically, what happened was Rosa filed her emergency injunction. The judge said, "Thank you for this, but for me to grant emergency injunction, I need to feel your pain. And to feel your pain, you've got to submit a complaint for a lawsuit." She said, "Okay." So she hustled her ass, wrote 202 pages, submitted a complaint like the next day. The judge said, "This is fantastic. Thank you so much. But in order to do a quick ex parte hearing, meaning just you and me and not the other party, I need a temporary restraining order." She said, "Okay." So the next day, she submitted a temporary restraining order. Judge's like, "This is great." Well, and then she contacted the judge a few times. She's like, "Please, let's have a hearing, let's have a hearing, let's have a hearing." And the judge said, "Quit contacting me about having a hearing. I may choose to have a hearing, I may not choose to have a hearing, but just stop calling my office. But I also need you to serve the other party and have that proof of service." So on the 22nd of December, she served FINRA's office and submitted that affidavit of service. And from that point forward, the clock was ticking, and that FINRA had 20 days to respond. And so FINRA's first response was to the emergency injunction and temporary restraining order, which said they cannot do. And FINRA's response was kind of garbage. It basically said, "We have immunity. You can't sue us, nanny boo boo. And even if you were going to sue us, we did the right thing by protecting investors because we protected them from the problems of settlement if there were 2 more days of trading," which is just garbage because there's been nothing but problems with settlement as a result of not closing out short positions, and we are in just a cascade of fire. They refuse to acknowledge anything about shorts existing on this ticker. They mentioned it twice in their filing, and both of them were times they're quoting Rosa as a reason why she was suing, and they didn't address it. So their filing was kind of dog shit. But the next day, they filed on a Friday. It was on a Monday. The judge threw out, dismissed the emergency injunction and temporary restraining order, citing FINRA's immunity, which was garbage because FINRA only has immunity to monetary damages, not to being sued in general. And there's countless times where FINRA has been sued and on grounds other than monetary damages and have lost. So Rosa submitted this on the 11th, which was the day that FINRA was supposed to respond to their supposed to submit the response to the lawsuit, and they didn't. They begged for an extension, and the judge gave them another 20 days for some reason. So Rosa's is 20-something pages. It is really, really brilliant. Here's what I'll do. I will get the Dropbox link, copy that, and I'll throw it into the chat here. Boom, boom. So you two can have access to what I'm looking at. So Rosa's is a memorandum in support of plaintiff's rule on this court rule 59 in a motion for reconsideration of order. So basically she's saying, "Judge, you didn't do your due diligence and look at the case law properly when you threw out my emergency injunction. I have every legal right for this emergency injunction." That's what she's saying right there in the top. So she's respectfully moves the court to pursuant to Rule 59 and Rule 60B of the Federal Rules of Civil Procedure to alter or amend its order entered on January 9th, which is the day that they threw out her emergency order. Defendant filed memorandum opposition to plaintiff's temporary restraining order. 1, absolute immunity, citing 1, absolute immunity. 2, alleging no imminent harm. 3, lack of emergency. 4, that plaintiff failed to demonstrate ruling in her favor would serve the public interest. 5, the Sherman Act was superseded by the Exchange Act. And 6, that there should be no remedy by ruling in plaintiff's favor. So what she does is she goes through these claims that FINRA made, and she shows not only that they are wrong in their claims, but when they cited the law, they did it misinterpreting the precedent that had been set by that law. So they'd say like in this court case, it shows that FINRA can't be sued. And then if you read the court case, FINRA got sued and lost. So like things like that, like it was pretty lazy on the part of the FINRA attorney and probably pretty lazy on the part of the judge too. Sorry, this is the look of a dog who wants to be under a blanket. I know, buddy. There. Is that what you want? Yeah, that's what you want. Okay. All right. So summary. This is about NextBridge hydrocarbons. It's giving the background to what happened. And she reiterates over and over again. So on like December 8th, the defendant was aware of over 9 million short positions that brokers and market makers were obligated to buy back and fulfill, which would have enriched shareholders, instituting the halt alleviated brokers and market makers. And she says that they know this because you just do not know how to go under a blanket. Just, if you stand on the blanket, you cannot curl up in the blanket. Okay. She said so by citing their own website. So she's like, their own website says that there's like a 27% short interest going on. So there's, well over 200 million shares in existence when there should be only 165 million. So she's using their own, FINRA's own sources to show that shit's fucked up. So it talks about how many shares they issued and the fact that their estimates of over 100 million unreconcilable shares, meaning naked shares or short positions that haven't been closed. And if they force NextBridge to issue the additional 100 million or more shares, that hurts her by devaluing her investment, right? So there's harm, and one thing that FINRA was claiming is that she wasn't showing how she was harmed by any of this. So she's explaining directly how she can be harmed by the remedies that are available, which is, well, why doesn't NextBridge just issue a bunch of more shares and they can use those and give them to everybody who bought? Well, that dilutes the value of the shares, right? It shouldn't be on NextBridge to produce those shares. It should be on the short hedge funds to take on that risk, because that's what you do. You take on risk when you short. So she said thereby diluting shareholders' interest. Or two, total loss by failure to receive shares of NextBridge hydrocarbons, because we're supposed to get a 1-for-1, right? We're supposed to get one NextBridge for every MMTLP. And if there are 500 kajillion MMTLPs, how do you give your 1-for-1 if there's only 165 million NextBridge? Okay, so those are the two ways she showed she was harmed. Defense halt was the benefit of the obligators, brokers, and short positions, basically saying FINRA puts thumb on the scale and help the bad guys. Defendants' consistent actions through the life of MMTLP have demonstrated actions in concert with brokers and market makers to alleviate the obligations of reconciling short positions and naked short positions, which violate securities law. So she's saying that when FINRA claims they were just doing their job as a regulator to protect investors, she's arguing that no, every time you've done something has been specifically to help those who took on short positions. And that's who should be taking on the risk, not those who invested traditionally in the stock. And then she says, by reinstating MMTLP, you can fix this thing with little or no burden to the defendant, because FINRA isn't responsible. Like, FINRA's not paying for this. They just say, hey, everybody, we're going to do 2 more days of trading. Let's go. Close out your positions. That's what they do. It's not going to cost FINRA any money to do that. It's a couple of tip taps in a keyboard. Bob's your uncle. There you go. Currently, there's no transparency from the defendant, brokers, or other market actors to explain, one, why the process of issuing shares in NextBridge hydrocarbons is taking over 30 days. Defendant's daily notice memorandum indicated 2 days and up to 2 weeks. So basically, FINRA's own daily notice said, oh, when NextBridge issues this stuff on the 14th of December, it should take 2 to 14 days. And here we are 40-something days later, and none of us can guarantee that we have those shares in our account. 2, what happened to the short positions documented in the daily halt was issued in the 45 days leading up to the day the halt was issued. So it was on the thresholds list because it had been shorted for like 40-something days in a row with FTDs. And so we know that there are tons and tons and tons of failure to delivers, thus naked shares out there. And 3, how the defendant and brokers resolved the reconciliation without an open market. Basically, you can't close positions unless there's a market available for you to buy up either the synthetics or the shares to replace synthetics with. That's what she's saying. So without an open market, no way to actually reconcile this. Without open market, shareholders cannot receive market value for their shares, and members whom defendant regulates benefit by excusing the obligation to return shorted shares to shareholders. Plaintiff requests 1. An accounting of all actual short sale, borrowed, loaned, or any and all forms of Series A preferred dividend MMTLP as was ordered in Ameriverse Securities Incorporated versus Financial Industry Regulatory Authority Incorporated. So she's citing case law of where FINRA has had to provide this information before. The reissue of MMTLP to preserve plaintiff's investment. So basically saying we must put MMTLP back into everyone's accounts for those 2 days. 3, a delay in the issuance of NextBridge hydrocarbons until a full reconciliation has occurred and shares outstanding is in balance with shares issued. So she's saying you put MMTLP back in everyone's account, you open up trading for a couple more days, you close out every short position in existence, and then you distribute the NextBridge shares to everyone's account. And which can be done because we have the certificates now at the brokers. We can easily say, okay, go to broker, go tip tap, open up the MMTLP QSIP again. We're going to spend 2 days closing, and at the end of those 2 days, then we can distribute finally all those NextBridge shares you have. So this is her main argument. This is the federal civil rule, a court rule that she's citing. A motion to reconsider under Rule 59E should be granted to correct a clear error, whether of law or of fact, or to present newly discovered evidence and to prevent a manifest injustice. So she's citing Firestone versus Firestone for this. A motion for reconsideration must show why the court should reconsider its prior decision and set forth facts of law of a strongly convincing nature to induce the court to reverse its prior decisions. So basically she's saying, court, you messed up. You got to reconsider, and these are going to be the reasons why. Defendant does not have absolute immunity in suits for equitable relief. So FINRA in their filing said we've got immunity, but they only have immunity from monetary damages. The self-regulating organization, SRO, FINRA enjoys absolute immunity from private suits seeking damages for actions within the scope of FINRA's regulatory authority. So this is DL Capital versus NASDAQ Market, so on. Plaintiff's lawsuit seeks equitable relief, not damages. So she's saying, I don't want money. I just want you to do the right thing and fix the problem. So therefore, you do not have immunity in this situation. Whether immunity applies will turn on whether an action against FINRA arises from the conduct within the scope of their regulatory function, and only in those cases seeking damages. Basically, if what they did was something they had to do as a regulator, you can't sue them for that. But if what they did is they claimed they were doing as a regulator, but were really jerking off the hedge fund the entire time, then you can sue them. Since this suit does not seek damages, but rather equitable relief and the ability to examine records, she underlies that, FINRA is not immune from this suit. In 2009, Amerivet Securities prevailed in a motion against the defendant requesting an accounting in the same nature as plaintiff's request and overcame absolute immunity and claims for equitable relief. Also, like the plaintiff's immunity of SROs and exchanges is limited to activities related to the regulatory function and not to its proprietary or profit-making activities. See Weissman versus NASAD. Firm relevant part, blah, blah, blah. Immunity applies only to regulatory activities, but not to other functions such as profit-making activities, advertising, or criminal activity. Absolute immunity is available to an SRO only when it carries out regulatory functions. SROs perform functions that would otherwise be performed by government agencies, including the SEC, would not be entitled to sovereign immunity rights for all suits. Would be entitled to sovereign immunity for all suits for money damages. So basically, you couldn't sue the SEC for regulating for monetary damages. Same with FINRA. So she's making the argument, yes, if I was seeking monetary damages, I wouldn't be able to sue them, but because I'm not, screw you. In order to determine whether the misconduct did or did not fall within FINRA's regulatory function or is intended to act in concert with co-conspirators depends on the facts that plaintiff can only determine with the ability to review the requested accounting. An accounting will reveal the current short and naked short positions of MMTLP, whether the defendant regulated bad actors and allow for reconciliation to occur, and preserve the 1-to-1 exchange ratio of NextBridge hydrocarbons without requiring additional shares be issued, which dilute the shareholders' investment. So she's saying, we have proof that there's shorts that still exist. Now we need to know exactly how many there are. And the court has already ruled in previous cases, FINRA's had to show that. And if shows that there's a whole bunch of short positions, naked or otherwise, those have to be reconciled before there's an issuance of NextBridge hydrocarbons. The proposed timeline of events to occur is set forth by the final prospectus. Imminent harm and deletion of actual assets, replacement by worthless tracking QSIPs. So she's now stating more harm that's happened to her by these QSIPs that keep popping up. Proposed timeline of events to occur to set forth by the final prospectus indicate a final trading date of the symbol of MMTLP on December 12, 2022, and deletion of the symbol on December 14, 2022, followed by a 1-to-1 exchange of NextBridge hydrocarbons within a 2-week period. NextBridge hydrocarbons has distributed to the brokers who have not issued shares to shareholders due to outstanding short and naked short positions. So we can't get the 1-to-1 because there's too many shares, leaving them unable to reconcile with the shares provided. As of the day of this filing, not one share of NextBridge hydrocarbons has been distributed to a single shareholder. It has been more than 30 days from the date of the halt imposed by the defendant. The imminent harm to plaintiff and shareholders alike is either the total loss of any rights to assets, MMTLP or NextBridge hydrocarbons, or the dilution of NextBridge hydrocarbons, both remedies harming the plaintiff. So she's saying, without having a market, plaintiffs are harmed. This is FINRA's fault. The defendant was aware of the 9,519,125 short positions existing as of December 8th, 2022, when they implemented the U3 halt, effectively insulating brokers and market makers that hold short positions from closing the short position at market value, thus enriching the financial interests of those brokers and market makers. Daily list notices are issued by the defendant and put brokers on notice of noteworthy events on a security that may be invested in, such as a spinoff into a private company like MMTLP. It allows brokers to take necessary steps to cover positions, invest, or divest. Although defendant had notice of effectiveness of final prospectus on November 25th, 2022, so weeks and weeks earlier, and failure to deliver MMTLP for 45 days straight, defendant issued daily list notices on December 6, 2022 and December 8, 2022, indicating purchases executed after 12/8 will not receive the distribution, informing brokers of deletion to occur at close of business on 12/22. Shorting volume in excess of 9 million then occurred on December 8th. At midnight, the defendant issued a halt of all trade activity to be lifted upon deletion of the symbol. Due to the excessive short positions and failures to deliver, brokers are unable to issue NextBridge hydrocarbons at 1-to-1 value and have provided a QSIP number that is not tied to any asset or shares in a company. The revolving doors of QSIP numbers indicate the inability to reconcile the 1-to-1 exchange, therefore immediate and current harm to shareholders, including plaintiff, that cannot be resolved until reconciliation has occurred. So she's saying, because part of FINRA's argument was, well, why is the defendant suing us if like other people aren't harmed? So she's now pointing out here, like, hey, it's not just me who is harmed. I happen to be suing, but it's all investors in this company who are being harmed right now. Plaintiff and shareholders are harmed by repeated issuance of new non-asset, non-company, non-value QSIP numbers, which have replaced the real asset of oil and gas held as Series A preferred shares. The unstable nature of the QSIP numbers, which have changed, are different across brokerages. Hold no actual value other than representing obligation and thus cannot be traded on an OTC market or stock exchange. They are not part of the exchange process and pose exponential harm to shareholders, as the current fulfillment obligation without access to OTC markets or stock exchange may only be redeemed by the dilution of NextBridge hydrocarbon shares. Basically, she's saying right now the only solution is dilution, and the solution of dilution is pollution for distribution. Okay. Emergency status of intervention during the exchange process before Emergency status of intervention during the exchange process before synthetic shares cause dilution. Plaintiff has sustained loss of oil and gas assets from deletion of symbol MMTLP and failure to deliver NextBridge hydrocarbons. As it stands, shareholders have a little recourse to receive NextBridge hydrocarbon shares without a prayer for specific performance. Ownership in a company similar to real estate is best remedied by specific performance. See this case. And Tyson Foods, this one here as well. Unique acquisition opportunity, loss of which cannot be quantified. However, this remedy would be insufficient as an order for specific performance would cause NextBridge hydrocarbons to be diluted and plaintiffs stand to lose either by total loss via failure to deliver or dilution of value. Public interest in ensuring that parties acting in concert do not dilute private company stock over which they have no authority. FINRA is a regulatory agency for stocks on a national securities exchange or over-the-counter OTC market. Defendants memorandum in opposition, introduction, blah, blah, blah. Private companies are not hosted on either the OTC market or any national stock exchange, meaning they do not fall under the jurisdiction of the defendant. The dilution and insulation of short positions on the OTC market has carried over beyond defendant's jurisdiction. So FINRA has no regulatory authority over private companies. So once they put the halt on and NextBridge went private, FINRA basically said, not our problem anymore. It's out of our hands, right? And so she's pointing out that the defendant, FINRA, created a problem and then shoved it off into this realm where they no longer have responsibility, right? It's like, I'll use the example when I was talking to her. It's like a county sheriff slowly chasing a defendant until they cross the county line and be like, well, bank robbers, that county's problem now. That's kind of what they did. Which market has carried over beyond defendant's jurisdiction, which is averse to public interest and beyond the scope of regulatory agents' purview and sphere of influence. To allow that dilution of a private company or mishandling of a private company beyond the bounds of the agency and due to the actions of securities market members and regulators will be a gross injustice and threat to the public en masse. To hold self-regulatory agencies and other agencies accountable by means of injunctive relief serves the public interest while preserving freedom from financial liability of the performing regulatory conduct. So basically saying, I'm not suing them for money. Again, I'm just asking them to fix the problem they created. Regulatory agencies are subject to antitrust laws, thus not superseded by the Exchange Act. Defendant erroneously cites Credit Suisse versus Billing to indicate securities laws preclude antitrust laws. Defendant's memo in opposition distinguishes SROs from securities underwriters to whom Credit Suisse is applicable. Investors harmed by underwriters' unlawful practices may bring lawsuits to obtain damages under securities law. Defendant has indicated that FINRA has immunity from lawsuits for monetary damages, distinguishing the clear intent of Credit Suisse ruling as evidenced in the amicus brief, which states Congress has made clear that the proper approach to a claim that a federal regulatory statute impliedly repeals the antitrust laws with regard to challenged conduct is an analysis which reconciles the operation of both statutory schemes with one another and rather than holding one completely ousted. Basically saying you can sue to rectify a problem they caused. You just can't sue for money. That's, again, what she's showing here. Okay. Finder of fact could, under the appropriate circumstances, infer the existence of a conspiracy in violation of the antitrust laws from evidence of discussions among alleged conspirators, combined with sufficiently probative implementing conduct. Citing the amicus brief. However, under circumstances of underwriters and an IPO syndicate, such discussions would not have probative value to establish that the underwriters were conspiring to engage in unauthorized conduct. Emphasis added. Antitrust immunity amongst underwriters allows for the necessary scheme of raising and assessing IPOs for future investors. In lieu, underwriters who have antitrust immunity are subject to liability for damages as a remedy. This is a direct contradiction from defendants' erroneous assertion of the intent and application of Credit Suisse ruling. Basically saying, if they conspired in committing a crime or doing a wrong, they do not have immunity in this case. And so she's saying we need an accounting to find out if they conspired to do a wrong. And if that's the case, then guess what? They have no immunity in this, even for monetary damages. The court has repeatedly rejected the view that all conduct regulated under another statutory scheme enjoys a blanket exemption from antitrust law. Cites another case. Activities which come under jurisdiction of regulatory agency, nevertheless, may be subject to scrutiny under the antitrust laws. So, citing again, case precedent that they can be sued. Likewise, the conduct of the defendant is not shielded from scrutiny under the antitrust laws merely because it involved in regulatory function if it utilizes that position to further antitrust violations. The court has recognized that the immunity doctrine does not sweep within its scope all conduct that bears any connection to the core protected conduct, amicus brief, blah, blah, blah. By parity of reasoning, implied antitrust immunity does not extend to conduct that occurs in conjunction with permissible underwriting activities, but can be considered separately without chilling authorized underwriting activity. Similarly, insulating the losses and risk of brokers and market makers at the expense of shareholders and public investors can be entirely separated of other regulatory activities conducted by the defendant. Basically, if you put your thumb on the scale, you have no immunity. Again. Ruling in plaintiff's favor, remedy is provided by interfering with taking and dilution at the expense of shareholders class, which plaintiff is a member. She's pointing out more damages. So by ruling in plaintiff's favor, the court can intervene before plaintiff suffers loss. So this is why she wanted the emergency injunction and why it's time sensitive and why they need to pick their ass up, get their rear in gear. FINRA erroneously claims the extraordinary event justifying the halt is uncertainty in the settlement and clearing process. This is the really brilliant one. I love this whole section right here. Torchlight Energy Incorporated, Torch, entered into a merger with Metamaterial Incorporated, creating the Series A preferred share known as MMTLP. It's actually MMATA or whatever originally. The record date to receive a 1-to-1 exchange of symbol MMTLP and 2-to-1 exchange of symbol MMAT was June 24th, 2021. Any trades made after June 24th, 2021 would not qualify for the MMTLP oil and gas asset preferred shares. On June 24th, 2021, trading on Torch continued until the close of business. As of June 28th, 2021, the settlement and clearing process was complete. So she's showing that in the past, when a preferred share or special dividend or something had a date of record, FINRA allowed trading after that date of record. And settlement, they didn't care about settlement then, right? So why was FINRA so concerned about settlement on December 9th, 2022, when on June 25th and 24th, 2022, they did not care? Settlement did not matter to them then. Why did it matter all of a sudden now? So on June 25th, 2021, trading on Torch continued until the close of business. As of June 28th, 2021, the settlement and clearing process was complete. And as of June 28th, 2021, trading began under the new symbol MMAT with no extraordinary events. Wah, wah. The merger of Torchlight Energy and Metamaterials is arguably a significantly more complex settlement process to settle. The exchanges occur for different rates and different rankings of stock, preferred stock and common stock. However, trading continued past the record date and settlement cleared without significant uncertainty. And the defendant did not interfere or halt trading. MMTLP was intended to be a non-tradable preferred share. However, trading continued on or about October 7th, 2021, contrary to the proxy statement published to the SEC June 11th, 2021. Short positions of MMTLP were recorded on the day it began trading, although it was not intended to trade. The timeline of events has consistently demonstrated a lack of regulation and imminent threat of harm to plaintiff that can only be resolved by equitable relief. Further, the defendant has been found of colluding with broker-dealers in their arbitration process and final judgment, citing the Wells Fargo case that came out recently, where FINRA was letting Wells Fargo select arbitrators who would rule in their favor. You're not supposed to be able to select your own arbitrators. Arbitrators should be totally random and unbiased, but FINRA was allowing Wells Fargo to put their thumb on the scale. Is currently undergoing appeal. Plaintiff's assertion the defendant has acted in concert with brokers and market makers is further enshrined by the findings of the Trial Superior Court of Georgia. The court found Wells Fargo and its counsel manipulated the arbitrator selection process through FINRA's dispute resolution program, where FINRA allowed them to redline arbitrators from the selection process. For the foregoing reasons, plaintiff respectfully requests this court grant the plaintiff's motion for the reconsideration to vacate its prior decision, thereby reconsidering the motions for preliminary injunction and temporary restraining order before the court. Rosa hit a giant home run with this sucker and killed it. She absolutely she hit every single solitary crappy point that FINRA made in their response and just brutalized it with a meat cleaver. It was absolutely, this was brilliantly written. She did such a good job. So there you go. I think I missed so there you go. There you go. Ecorleto 46. And I missed some super chats while I was doing that. So there's a brief explanation. How long was it? 20 something pages? 19 pages. 19 pages. Quick, succinct, beautiful, well done. And hope Rosa's enjoying her vacation and hope she's getting lots of sleep.